Hey guys, we're going to be talking about insurance fraud in the PIP statute as it's listed. This is subsection H, subsection I. Really quick, no payments are due when there is insurance fraud, when it's admitted or established in court. Any fraud, I have seen patients admit to insurance fraud in an EUO, which is under oath, so that's admitted under oath. And I've seen it established in court. That's when the insurance company sues somebody, or when a PIP suit is done on a really bad case where there's probably fraud and the doctor doesn't want to say there's probably fraud somewhere in there, and they go to trial and a jury says, yeah, there's fraud there, then that would be bad. So anyways, yeah, hopefully you don't have a PIP attorney who does that kind of stupid stuff. But anyways, any fraud equals voided coverage. There's no policy when there's fraud, and there's a legal standard. It says any fraud in the part equals fraud in the whole. If there's any corruption in the piece of the case, whether it's the patient, the doctor, a billing company, a lawyer, whatever, it makes fraud everywhere, okay? Any benefits paid are recoverable. So let's say they pay a doctor a portion of the bill, and then they realize, oh my God, there's fraud here. We've got them by the book. We've got it admitted to under oath, or we've established it in court. The doctor, medical provider would have to pay that money back. If it was the patient, they'd have to pay that money back. There is also a prevailing party rule that entitles the insurance company or the doctor to get their attorney's fees and costs paid back. So it kind of changes the game if there's insurance fraud. It gives the insurance company a lot of power if they can prove that there's fraud. Subsection I, if an insurance company has reasonable belief of fraud, the insurance company shall notify the claimant, whether it's a doctor, the patient, whoever, in writing within 30 days after submission of the claim. So it's not notice of the loss, it's when they get a bill. Okay, hey, I want you to pay this bill. They have 30 days to notify the claimant in writing. That gives them an extra 60 days to investigate the claim. So I did regular math growing up. 30 plus 60 equals 90. So that gives, at the 90-day mark, the insurance company must either deny the bill or pay the bill with interest, okay? 90 days, that's 30 plus 60. They have 90 days to pay the bill with interest or deny it, okay? All claims shall be reported to DIFS. Now, we all know there's one or two insurance companies out there that say everything is insurance fraud. This is insurance fraud, that's insurance fraud. I had an adjuster call me, okay? This guy said that my client, who was in a car accident and had 2 MRIs, that he was committing insurance fraud because he wasn't hurt from this accident. He was actually hurt from a motorcycle accident he had 2 years ago. And I was, are you kidding? Are you serious? You're calling me about this? What a waste. So I said, did you report it to the Department of Insurance Fraud? And he said, no. And I said, you're breaking the law. You're committing fraud. He didn't like that. He hung up on me. No one likes that guy anyways, but this is the statute on insurance fraud inside the PIP statute. They have a couple others, but this is the main one. This one says if there's any fraud, it's voided and the insurance company can get their money back and their attorney's fees. This one has a requirement that the insurance company notify the Division of Insurance Fraud and gives them a 90-day. It gives them an extra 60 days to pay a bill. As opposed to the traditional 30, it gives them an extra 60 for a total of 90. Thanks for tuning in.